If you aren't already aware of the happenings with this token, you should be. In the coming months, XRP will reach new all-time highs. But first, I'd like to announce the winner of the 25 XRP coin giveaway. The winner will be announced at the end of the video, so stay tuned to find out whether you've won. Let's get into the video now. Welcome, let's help my channel develop by liking and subscribing to it. We're going to speak about XRP and all of its good triggers in today's video. With the current state of affairs, it looks that the US Regulatory Commission is under pressure, as foreign authorities have begun to question the SEC regulatory oversight of the crypto field. With the government's watchdog on board with this lawsuit, things have already become crazier. Empower oversight suspects that the SEC is engaging in questionable activities related to the conflict of interest of the majority of its key personnel. Apart from that, there has been another occurrence in the case that may be deemed tedious for Ripple, particularly XRP. So far, we've seen Empower Oversight, a nonprofit organization that filed a thorough Freedom of Information Act request to the U.S. Securities and Exchange Commission seeking correspondence between SEC employees and their present and previous employers. Well, the organization feels that SEC personnel have a conflict of interest, and William Hinman is the first target for the same. We're sure you've heard his name mentioned multiple times in this litigation. He's quite well known. William Hinman, a former director of the Securities and Exchange Commission's Division of Corporation Finance, once stated in a lecture that Bitcoin and Ethereum are not securities, but rather cryptocurrencies. Furthermore, the SEC filed the claim against Ripple only after Hinman departed the SEC to work for Simpson Thacher in December 2020, according to the organization. Simpson Thacher is significant because, before joining the SEC, Hinman was a partner there, and after leaving the SEC, he returned as a partner there. This firm is a member of the Enterprise Ethereum Alliance, an industry organization whose goal is to promote enterprise Ethereum adoption. The leader of the SEC division that brought the XRP complaint, Mark Berger, departed the SEC for Simpson Thacher in a similar manner. Former head of the Securities and Exchange Commission Jay Clayton, the chairman of the Securities and Exchange Commission, walked away in the same fashion. The organization suspects Jay Clayton of mishandling Bitcoin issues at the SEC. Mr. Clayton stated unequivocally that Bitcoin is not a security. With the filing of the SEC action against Ripple, Mr. Clayton's tenure at the SEC came to an end. After leaving the SEC, Mr. Clayton joined One River Asset Management, a cryptocurrency hedge fund focused only on Bitcoin and Ether. According to the most recent developments in the case, the court had to extend the fact discovery deadline due to the accommodation of Brad Garlinghouse and Chris Larson's depositions. The Securities and Exchange Commission, Ripple Labs, and the individual defendants have filed a joint motion to extend the fact discovery deadline. For everyone involved in the business, from XRP investors to digital asset exchanges, this might be a regrettable turn of events. Fintech companies, partners, and clients who wish to see this matter resolved as soon as feasible. The court is asked to enable the SEC to take depositions from Garling and Larson after the fact-finding deadline of August 31, 2021. Due to the sudden illness of a counsel for one of the parties involved in Chris Larson's deposition, both parties have made such a request. The court did agree to extend the fact discovery deadline, which means the expert discovery deadline will be extended as well. The parties may take depositions from defendants Brad Garling and Chris Larson after the fact discovery deadline of August 31 has passed, according to the judge. The time for expert discovery has been extended to November 12th. The deadline for the parties to exchange their separate statements of material facts and their letters addressing applications for summary judgment is approaching. The judgment has been adjourned sine die pending the outcome of the request to dismiss and strike, as required by Local Civil Rule 56.1. Adjourn sine die, as defined by James Fillon, is a date that has not been specified for the submission of the pre-motion letters, since such dates are contingent on when the court rules on the outstanding motions to strike and dismiss. Before the further documents can be filed, those motions must be addressed, and we have no clue when that will happen. Well, this is the second time the judge has moved the dates. The SEC was granted a request to extend the fact and expert discovery period by 60 days a few months ago, against Ripple's opposition. Even Ripple Labs agrees with the conclusion this time. Now the real question is when this litigation will be over. According to James Fillon's calculations, this is a war. I believe we should prepare ourselves for the long haul. The SEC now has the upper hand in the case, noting in its recent motion that there is no realistic chance that the parties will fully resolve this issue for some months, if not longer. things in the SEC vs Ripple litigation have taken a turn for the worst. Despite the fact that the court judgment favors the SEC, Ripple's palm bears more weights. A piece of information from 2019 could now be regarded significant evidence in Ripple's fair notice defense to demonstrate whether XRP is a security or not. Previously, John Deaton represented approximately 12,000 XRP holders in the dispute. To protect their own interest, they filed a move to intervene in the case. Despite the fact that the court had ruled in favor of the intervention, the case was still pending due to an objection. The Securities and Exchange Commission (SEC) submitted a report. On August 26, 2021, John Deaton published a video from Consensus 2019 titled Perspectives on SEC Engagement with Digital Assets on Twitter. The participants in this video, which was initially published by Twitter user CryptoCouncil, discussed the SEC and the digital environment. According to a transcript provided by the website Finance Feeds, the dialogue clarified that before Coinbase's listing, Coinbase had stated that they wanted to verify that XRP was not a security. For the same reason, before Coinbase lists XRP, the platform ensures that its qualified legal team examines tokens to guarantee that they are not securities. Listing a security will be a violation of securities laws, according to Coinbase's standards and procedures. However, following the filing of the complaint, the platform delisted XRP, although its claim that XRP was not a security from February 2019 to January 2021 remains unsubstantiated. Furthermore, now it's time for me to choose the winner of the 25 XRP coins. Vikrant Date is the winner. I'll send you a message on YouTube with further information. Let's return to the video now. Transparency of Coinbase's framework and procedure with current and potential regulators. If XRP holders are granted the opportunity to be heard in this case, John Deaton says he will submit the following material on their behalf to highlight that regardless of whether XRP was a security in 2013-2017, it's ludicrous to argue that today's token is a security. Amy Starr, Chief of the Office of Capital Market Trends in the SEC Division of Corporate Finance, and Dorothy DeWitt, General Counsel for Business Lines and Markets at Coinbase, were also featured in the film. In addition to William Hinman, whose deposition or name was mentioned, Amy Starr is likely one of the fact witnesses from the SEC that Ripple chose to depose. He went on to say something about the SEC official and the video. Dorothy DeWitt, Coinbase's General Counsel of Business Lines and Markets, made these comments 3 months after Coinbase listed XRP. According to John Deaton, he went on to say that XRP was a widely recognized token that was specifically designed as a non-security. Furthermore, despite the fact that the SEC, as a legitimate government regulatory organization, was an expert in new blockchain technology, it opted to sue Ripple after 8 years. Clayton's final day was therefore even more arbitrary, capricious, and suspicious. The SEC is under a lot of strain in the current situation. Now it's up to the judge to decide what happens next. But until then, the price of XRP is unquestionably in your hands. The token is benefiting from recent developments in the matter. In that event, XRP will almost certainly be classified as a digital asset rather than a security. From a technical standpoint, the token is currently trading at $1.14 with a green of 0.32%. A bullish environment for XRP is indicated by a favorable trend. However, if the token is to prove that it is on the rise, it must first break through the $1.19 resistance level. Since Ripple has already revealed a new development in smart contracts that could push the XRP ledger to compete Ethereum and BSC, the same goal does not appear to be too far away. Rather, XRP will be pushed to the upper resistance levels with a small push. You should keep a close eye on this token because XRP is expected to skyrocket by the start of 2022. If the bull continues to rise, the price surge might start as early as November. So, if you see XRP rising, go in as soon as you can. If you want to learn more about XRP, there are 2 more videos on the end screen that you can watch. Please consider subscribing and giving us a thumbs up. Thank you for viewing, and I hope to see you in the next video. Please keep in mind that cryptocurrency prices fluctuate regularly, so by the time you see this video, it may have changed to a completely different value. You should not regard any of the content in this video as investment advice, financial advice, trading advice, or any other type of advice. The information in this video is provided solely for educational purposes and should not be construed as financial advice. Before making any investment decisions, do your own due investigation and talk with your financial advisor.